A pleasant good afternoon, everyone, and welcome back to one of our Sustained by Grace Ministries and Outreach program where we nurture you back to wholeness and life. Last week, we were not on, and we do apologize for any inconvenience caused. Our speaker should have been with us last week. However, he is with us this week to continue where we left off. And we want to say it is always a pleasure to have you with us. And we're happy that you always tune in every week, listening in, logging on to Zoom, and being a part of us. We thank you tonight again for being with us. And I know we just celebrated Mother's Day, and we want to take the time out to say happy belated Mother's Day to all our wonderful mothers, knowing you are all God's special people. And also we are celebrating Child's Month. So we want to say Happy Children Month, or Child's Month, to all our children. And we do hope you realize that you are our future posterity. And we want to groom you and grow you so tomorrow you'll be a beacon in this world for God. We thank you once more for joining us. For those who are tuning in on YouTube, those who will be joining us on Zoom, and those who will be watching the delayed broadcast later in the week or months or years to come. Thank you for being with us another time. And before we go any further, I just want to share a scripture with us. And as we said before, there's nothing that we do on earth that is not mentioned in the Bible. So we look at the scripture the last time, and we're going to continue with it. Psalms 2, verse 8, reading from the King James Version. The Lord said, "Ask of me, and I shall give thee the heathen for thine inheritance, and the uttermost parts of the earth for thy possession." Solomon 8, verse 11 said, Solomon owned a vineyard in Baal-Hamon. He leased the vineyard to tenants. Each was to bring for his food 1,000 pieces of silver. I wonder what 1,000 pieces of silver is like in today's currency. But we will be looking tonight on estate planning, as we should have done last week. But we are zeroing in this week on titling and also tenancy. And our guest will be joining us shortly. But before he do so, I'm gonna invite Marvin Lemar just to bring a sentence, just one sentence or word of shout out or greetings tonight from our program.
Well, greetings to all, to our special guest speaker, Reverend the Attorney Tristan Russell, and of course to all our guests and friends all over, viewers, listeners. Certainly it's a good time to be tuned in, and especially since there's a lot of persons who will be getting some raise, whether in the civil service or in the private sector. Think about purchasing land and otherwise getting your place up to speed with your title, etc. So you're at the good place and at the right time to get that information. And I hope tonight will be of such to you going forward. Thank you. Slamar.
Thank you very much. Well, that was a good one. So all the raise. Well, I hope I can get some of that raise and also do as you say. And I'm sure our listening audience would like to do so as well. So tonight we're going to really be discussing titling and tenancy. And we know that a lot of us, whether home or abroad, sometimes experience problem in these areas. And we are here to help you to straighten out those areas. And if you should need individual consultation, also remember that our guest speaker is a lawyer and you can contact him for further information. However, our information tonight is just general information as we seek to educate a wide cross-section of people. So it's not to be dealt with as a recommendation for any specific problem. Again, we said if you have a specific problem, please to consult with the professionals, right? And you can do so with our guest speaker if you so desire. He will give you his contact details afterwards. So let me take up no more time and just introduce our guest presenter to you at this time. Give me a second here. All right, so Sir Tersata Kirkpatrick Russell is our presenter, was born in Manchester, grew up in Clarendon and now lives in Kingston. Got saved in grade 3 and he is a member of the Good News Relief Center of the Prophetic Church of God. He has been very active in ministry and he served as one of the 2 international youth leaders and as host pastor for the branch in Crooksgate, Clarendon. He's an attorney at law, having been called to the bar in 2012. He recently transitioned from the government service to being a sole practitioner dealing with civil matters. He's also a justice of the peace. He likes to sing and want to live to show the love of Jesus to everyone. Put your virtual hands together as we welcome tonight's guest presenter, Pastor Russell. Good night, sir. You can take the floor. You're muted, sir.
Thank you very much, ma'am. Thank you very much also to Rev who spoke earlier and to all those who will be listening in on this presentation this evening. Could I be allowed to share my screen? I also want to join you, ma'am, in wishing all the mothers a happy Mother's Day, although it went on Sunday, and also for the children, a wonderful Child's Month. When you were reading the introduction a while ago, I realized that I made a step from the government service into private practice. So I won't share in much of what is going on now, but for those who are going to be a part of it, I am happy for all of my colleagues. Yes, I thank you very much. So thanks again for the opportunity. And I trust that we'll have a good time discussing this part of the presentation. I trust that everyone will be able to see what I'm sharing. Can you see my screen? Okay. And today we're going to be talking, this evening we're going to be looking at the land part of the discussion. We have been talking about estates. We did an semi-comprehensive discussion the last time about estate planning. And now we're going towards discussing matters surrounding land. For those who would like to contact me, this is my contact information. If you're sending a written correspondence, 66 and 68 Barry Street, Kingston, and my number is 3509024, and my email is tisraelkr@gmail.com. Feel free to give me a shout if you have any specific problems, as the moderator would have said. So on to the discussion. We're talking about land matters. And as a foundation, I want us to bear in mind that there are two major categories of title to land. These categories are the unregistered title and the registered title. Now, these different titles, if you have an interest in property with these titles, you will have to go to different places. So if you have an unregistered piece of land, your place that you will have to look at or go to is the records office. And there you would have what they call various documents that you would have to look at to prove what is called a root of title. I think in Jamaica we call it the conveyancing system, where persons will pass a conveyance from one person to the next, and what it does, it shows a link from A to B to C to the current person. So it is important that if we are dealing with persons who are with property that is unregistered, that we would search or research the title to make sure that the person you are dealing with is a proper person, because land is a commodity that many persons will try to sell, even though it does not belong to them. So we have to be careful with this type of title. The other type of title, which is more secure, is called the registered title. And the registered title will lead us to a place called the Titles Office. Another name for it, National Land Agency. Now, you will notice that both systems, both the registered and the unregistered, are in a written form, or call for a written form of proof that a person owns land. And I'm going to get towards that, but I want to make it abundantly clear. According to a piece of legislation called the Statute of Frauds, once we are having any dealings with land, it must be evidenced in writing. And so if it is unregistered, you need a conveyance, which is still written. If it is registered, you will get another type of proof, which is called a registered title, a document called a registered title. And there is what they call a register book that deals with volumes and folios. We'll talk a little bit more about that, but I just wanted to lay that foundation. Now, for the unregistered system, once you, and also for the registered system, once you have a notation made, or once something is written down, it is considered to be noticed to everyone who wants to deal with the property. So once it is conveyed to X, or it is sold and a title is made out in the name of X, then everyone who goes to either of these places will be deemed to have notice or an understanding that X is the new and true owner. Now let us just look a little bit more into these two systems or two types of land, as we have spoken about, a title system, two types of title. In the unregistered title system, it is what many people in Jamaica call the common law title. And the common law title is based on claims to titling land and on a person being able to establish what is called a good root of title. And how do we do that? Through researching the conveyancing documentation at the records office. Now, for conveyancing transaction, where we're talking about common law kind of title, you have to go back to some 60 years in order to prove that, yes, you would have been satisfied that everybody who has an interest would have been accounted for. Now, I'm just putting this for information purposes. The Vendors and Purchasers Act, Section 5 says, in the completion of any contract of sale of land and subject to any stipulation to the contrary in the contract, 40 years shall be the period of commencement of title. So 40 years according to the Vendors and Purchasers Act, but many times we go a little bit further to ensure that all the bases are covered. Now, just to say that with this type of title, it is labor intensive because you have to go and you have to search through the records at the records office, the conveyancing documents to see how, and you'll have to look carefully because some of these documents were written a long time ago and they may be dusty, and you have to do a lot of inspection to make sure you're seeing the correct names. Yes, so it is laborious. Unregistered title system. I want to just say again that if you're, because many persons in different parts in Jamaica are interested in purchasing land that have the unregistered title or are under the unregistered title system. What must be done is the due diligence of searching to make sure that you have looked at the conveyancing and you know whether the person that is presenting you with this opportunity to buy land is the proper owner and the person with whom you should be having the conversation. On the other hand, there is a registered title system. And in Jamaica, we have what they call the torrents. Yes, and then they have also what they call the cadastral mapping. But the Privy Council gives us the main reason why we need to edge or err towards the registered type of land ownership or title system. And it says the object is to save persons dealing with registered proprietors from the trouble and expense of going behind the register in order to investigate the history of their author's title and to satisfy themselves of the validity. So as I was saying before, under the unregistered system, yes, you can deal with that kind of land and you can purchase it, but it takes a lot of investigation. And so the registered system came into place to prevent persons having to go through that. So it instead of having, persons having to look through, laboriously, the registered system is such that persons now can rely on a register that is kept up to date and it has all the transactions, and this system therefore is more reputable, and persons have an easier time dealing with properties under the registered system. Now, as I was saying earlier, It's a safe way, the registered system, safe, simple way of dealing with property. It also gives you a quick, up-to-date record of who is the owner and who are the interest holders. And the registered title is guaranteed. There are certain principles that guide the registered system: the mirror, the curtain, and the insurance. Once you are dealing with the registered system, you don't have to go and do no investigation. Whatever is on the title, they call it the duplicate certificate of title, because there's only one original title, and that original title belongs to the government, and it is kept at the National Land Agency. It doesn't leave. Everyone who has their original title, so to speak, really has what they call a duplicate, a second copy of the certificate of title. And once you deal with that and it is up to date, then guess what? You don't have to do the investigation. Now, this allows us to solve many disputes quite easily. I want to also let us know that the Register Book of Titles is nothing secret. It's public knowledge. You can actually access it from anywhere. There is a website called the Elan Jamaica. You can go on, and once you have, given them your credit card or your banking information, you're able to access copies of title, copies of different documents, copies of information related to caveats. And once you do those kind of searches, then your heart can be at rest that guess what? You're in a good hand and you're going forward in a good way. And this is the kind of registration that public or financial institutions prefer because of the ease that it allows when it comes on to dealing with properties. When you're doing a sale, you don't have to do any investigation. You only show the title and you're good to go. And because of the nature of the title, then you can have dealings going forward with confidence. And it also reduces the cost that would have been associated with dealing with land. It reduces the cost, and it protects a category of persons that we in law refer to as equities darling, or what is called the bona fide purchaser for value without notice. It protects equities darling, protects you from making certain mistakes that you would make ordinarily, or having your property, slip through your fingers. Persons can know that, guess what? X is the owner and no one else. If anyone else comes, they have to present you with a power of attorney or some authorization that shows who they are and the connection with the person who is named on title. Now, I'm going to come back to this slide, so I will just slip from this. But needless to say that when you have a registered title, there is ease with which you can transfer your property. So you can have your name taken off, you can have your name or names of others added to. You can have corrections being made to your name, and the bases on which persons do these are either for value or based on love and affection. So I can decide that I'm going to sell my land for $1, $2, $10,000, whatever the consideration. Or I can say, oh, I have my brother and my mother and my father and my sister, and I want to give it to them, and I can give them based on my love and affection for them. So there are different things you can do, and it is easier to do these things when you have a registered title. Now, I wanted to speak a little bit on co-ownership because of what our moderator asked me to deal with. You can have, and this is co-ownership is when 2 or more persons own land. Now, Two or more persons can own land, and that is referred to as co-ownership. There are different types of co-ownership. There's a type that allows for everybody to own everything but nothing. So if 5 people are on a thing, all of them own it, and if they want to do anything, all of them have to agree. So it's as if they become one. But what happens with that form of co-ownership, which is referred to as the joint tenancy? It operates based on a domino effect. So if 2 persons are there and one falls down, the one that remains standing becomes the owner. So that with the joint tenancy, the last person standing, the last person alive is the owner of the entire thing. Meaning that the person who would have fallen, so sad for them, they could not have left any interest in the property to anyone because their interest died with them. The interests of persons who are co-owners under the joint tenancy system, the interests all die with them, except the last person who is alive. And if you have a situation, just for your own knowledge, if you have a situation where 2 persons, a husband and a wife, they are in a car accident, both of them perish, and then you're wondering who is going to be the person who is going to get everything, it will be the younger of the 2, because in law, the younger person is presumed, especially if they don't know the times of death, is presumed to have died last because they would have had longer potential at life or more life left in them. So the joint tenancy system operates on what you call survivorship. It is where the last person who is standing, the last person who is alive, they become the absolute owner of the property in question. And we're talking about registered system. So if a person, if a husband and wife have a property, the husband dies, the wife is alive, in order to claim her interest, all the wife has to do is to do what is called, a notation of death. The notation of death will do what you call a clearing off of the person who has died. And that notation will indicate that the person who is alive now is the absolute owner, and that person can make steps or take steps to have the property sold, have the property leased or rented, etc. Now, the other type, and I should have said before that the joint tenancy is usually done in husband and wife or very close relatives. When it concerns tenancy in common, this is where persons have actual or divided shares in a property, and it's more common in cases where you have siblings or you have other family members other than those who are husband and wife. So you'll have persons having 1/3 share, 3 persons having 1/3 share each. You'll have some having 7/8, some having 1/8, and the fractions are varied. Yes, so but the important thing with the tenancy in common is that each person holds an interest both in life and also in death. So if a person dies in the tenancy in common, it doesn't stop them from saying, hey, or from their relatives saying that, guess what? My relative was a part of this situation, and therefore whatever they had has to fall to their relatives. And so our names should be put instead of their names or swapped. And we did speak about the ways that we can deal with that last week, so I won't go over that. We also have another type of interest I want to make mention of right here, which is called the life tenant. And the life tenant can also be a co-owner as well, because a mother may feel that, boy, I have a few more years to live, but I don't want to give my children any trouble. So what she will do is that she will take her title and say, you know, I want to put my children's name on, and then I want to give myself an interest for the rest of my natural life. So that whenever I pass away, all they have to do is to do a notation to say, okay, and you know, present the death certificate, and they can continue with their business as if I were never in the picture. That is called a life tenant or a life interest. The interesting thing about the life tenant is that although they are there and their interest would be just for their natural life, similar to the joint tenant, they have the opportunity to, if they are standing by themselves, to make certain decisions where it concerns the disposal of the property. They can decide to sell the property. The only thing is that it cannot be for their benefit, because in the long run, anyway you take it, the life tenant can only benefit from a life interest. So what they would have to do is if they sold the property, they would have to put the funds in an account for the benefit of the persons who are coming after them, or person, as the case may be. Now, if you are living on unregistered land, I want you to know that you can apply for a registered title. So you're not condemned to one type of title forever and a. How do you do this? You will need to get some persons who are called declarants. And declarants, because you're going to be the applicant, and the persons who are the declarants, they are going to be supporting the story that you're going to be putting towards the National Land Agency. You will also have to prove that you have been paying taxes. And it is for this reason that you hear many people say, oh yes, we're paying taxes. So for me land, taxes go a far way in persons, in the lives of persons who are interested in getting registered title for their properties, but it is not the be all and end all. You also need to make sure, I'm coming to something that's very important in this section of the discussion, but you also need to get a pre-checked survey diagram, and you will get that from a commissioned land surveyor who will check to see that pegs are in place and give you certain information like a PE number, preliminary examination number, which you will have to give to the put in your story to the land agency. You'll also need to have a valuation report and a certain format that is supposed to that your story is supposed to be presented in. But one of the most important things for you to have is the fact that you are in possession. Now, the law teaches us that possession is 9/10 of the law. It is most important. So if you are just looking on a piece of land and you say, oh, that piece of land is over there, and I took possession of it, or I am in charge of it, and I'm just paying the taxes, and you are not in possession, then you need to get your your affairs in line, because without possession, you are not going to succeed, especially if you are, at least when it concerns land that you are trying to get registered in your name that you would have obtained on adverse possession. I call the name and now we're at it. Adverse possession is where a person enters into possession of a property that belongs to another person or to other persons without the permission of those persons or that person. For you to be successful, you need to be there undisturbed. And once you're there undisturbed, then you, based on the limitation, after a certain number of years, you are able to claim the property as your own. I did already say under the Vendors and Purchasers Act, 40 years. So I think in the case of Crown land, it goes up to 60 years. So the more the merrier. And if you have been there for the amount of time, what happens over time is that the owner, or the paper owner as we call them, they lose their right. So they may have their title put up very securely in their Dulcimania grip, or very nicely in a safety deposit box, but because they have ignored the land and someone else would have had eye on it and would have possessed it and would have been paying taxes for it, then the right of the piece of paper that they have, although we spoke of it so highly earlier, this piece of paper becomes nothing. It becomes just like an ordinary piece of paper out of a ream of paper. And so therefore you cannot claim anything much out of that, because you lose your right to the ownership and etc. of the property. Just that everybody's understanding me clearly. Now, any land can be adversely possessed, and the Limitation of Actions Act, I had the years set out. If the land is registered and the owner ignores it for 12 years, once you reach 10 years, then them corners start to get dark. Yeah, they have to, it's going to be very difficult for them to prove and to say why they were out of possession. If it's unregistered, it's 30 years. But as I said before, the more years you would have had, been possessing the land, then it would have been better for you, and more the merrier. Once you are there for 60 years in terms of Crown land, then the land can become yours under the system of adverse possession. Now, if you have the property and you have been successful, with these under adverse possession or under any of the titles I mentioned earlier, there are certain actions that you can take where the land is concerned. And I did mention two of them before. You can actually transfer the property to others, so you can give them based on value. That means money is paid. Or you can do it based on love and affection in case of family relationships. But then there are also three things that I wanted to mention here. You can license the property, you can lease the property, or you can sell the property. And let us look on those in the order. Again, I want to just mention to everyone, if anyone is dealing with any land, with you, and they come and say, boy, just let us just start a thing, and you're over in America, or you are doing so and so, just send me $1 million and we can, start, and then we can do X, Y, and Z after. Let us remember what the statute of frauds say. Agreements that are related to land must be evidenced in writing. That means they must be in writing. They cannot be oral. The oral contracts concerning land are contracts that might just be what you call unenforceable. So you would have had all your right and lost it. What's a license? A license is basically this: just permission to use or occupy land. And this is many times in my experience what many persons refer to as a lease in Jamaica, because you get an opportunity to use, and perhaps I'll correct that. You'll find a lot of licensing situations across the country where persons get a short term duration, on, property. And the most important thing is that it's just permission. No interest is granted, and is usually for a short term. It can be extended, but really and truly, the licensor, who is the person who gives the right or the permission, grants to the licensee, the person who gets the permission, just permission. And so at any time, the licensor can go in and can revoke or take back the permission that was granted. There is another type thing you can do with your land too. You can lease it. And a lease is said to be exclusive possession for a term certain at a rent. Exclusive possession for a term certain at a rent. This is many times what we see. And I should just go back a minute. A good example of the license is where you have a lodger. For somebody who is going to school and you give them a permission to occupy your premises, and they call it room and board. So you provide them with meals, you provide them with basic furniture, probably internet, and they are to come out as soon as school is finished. And when they are gone, they get it ready for somebody else. They don't get anything. They're just persons who pass through. They use, you benefit, they benefit, you benefit, everybody is happy. The lease, however, is not, it's sort of different from the license. There's a case called Street and Mountford, which said that for you to have a lease or a rental situation, you must have exclusive possession. That means the person must be able to exclude people from the property, including the landlord, including the lessor. So once the person gets possession, and the evidence of possession is usually the keys or the right of access, the landlord is no longer permitted to come in and have free will or free reign. And it must be for a certain term. So, and this is because they don't want the lease to be forever and a day. It must be, you must know, it must have a definite start and a definite end. And you must be able to see that in the terms of the contract or agreement that you have. And it must have a consideration element, or what you call money that exchanges hands. Some bartering would have taken place. You're going to get my property. I'm going to get some money in exchange for it. And in the course of doing all of that now, you have what is called a proprietary interest that is granted from the lessor to the lessee. In plain terms or in common parlance, the lessor is the landlord and the lessee is the tenant. I just wanted to, for our information, give us some do's. Persons who are renting property, make sure that the landlord is duly authorized. If the property is registered, you're going to be asking for the duplicate certificate of title, or going to the titles office and checking it yourself. Or if it is unregistered, then perhaps you'll have to go to the Island Records Office to do the investigation, or you're going to perhaps ask an attorney to assist you to do what we call the due diligence checks to make sure that you're dealing with the proper people. Secondly, make sure that whatever you're doing, it is reduced to writing. There must be, according to the statute of frauds, if you're going to be on the right foot, there must be some writing that is there to evidence that there is a contract between the lessor, the landlord, or the lessee, the tenant. And when you get a contract, don't just sign. Check, ask questions, and seek the advice of qualified persons to decipher what does it mean. So make sure that terms are there that will help you. You should make sure that you can get out of the situation. There should always be an exit clause that if anything happens and you need to make a quick run, you are not tied to the situation. The terms must be there to protect you. Now, what you should make sure you do is ensure that the landlord or the lessors and the tenant, as the case may be, there are covenants or terms that are standard and that must be there. So in terms of the landlord is supposed to keep the property in a tenantable repair. So it must be in a way that the tenant can live and live happy. The landlord should give peace and quiet to anyone who is paying their rent. Now, the only disruption to this, if the tenant is not paying rent, the landlord is obliged or can avail himself of the right to give notice. But the landlord don't have any right to go and tear off door, tear out window, and make your life a living hell, turn up noise. No. But ordinarily speaking, if you are paying your rent, the tenant is entitled to quiet and peaceful enjoyment of the property. The landlord should also pay the rates and taxes punctually, on time, so that there's no problem with the property. And if there's anybody who the landlord causes to come onto the property and there's any damage that is done, the landlord should indemnify or put a situation of protection for the tenant where anything that you would have lost can be covered. Using the common parlance again, when it comes down to the tenant is to make sure that the property is kept in good order, except things that deteriorate naturally over time. And in law, we call those fair wear and tear accepted. So, you have some things that really and truly, when you look at it, with the passage of time, that would have gone, so you understand. The tenant is also to pay their rent on time. And usually, it is stated in the agreement, payment by or before X time, they are supposed to pay the rent on time. The tenant is also to keep the premises sanitary and not to do anything that will cause nuisance when it comes on to the neighbors. Tenants should not cut trees or cause any damage. We remember that they have a proprietary interest, or the property will result back to the owner at the expiration of the lease. So they should be careful not to destroy or damage anything. The tenant should also not waste the amenities. So things are there, take it and just, allow it to go as how you feel. Oh yes, because, I'm the one over here now, so I can do as I please now. And there are going to be times when, although you have exclusive possession, the landlord would want to come in to see that things are okay. So the tenant is supposed to permit the re-entry of the landlord at reasonable times to come and have inspection, not as the landlord feels, because the landlord has to give notification of the re-entry or the inspection to the tenant. And they are not supposed to assign or sublet. They are not supposed to get anybody who they are going to rent out a portion of the property or give all the rights. So when they assign it now or sublet it, is either they're going to say, oh, my cousin is going to come and stay with me, or I'm going to allow my cousin to come and stay here instead of me. So they will become a secondary lessor or landlord, and the new tenant will be their responsible to pay them, and then they will be responsible to pay. If these situations are not provided for in the agreement, they are breaches. So those are things that are not to be done. A note to lessors: make sure you have your proof of owner. And I'm talking to landlords who may be listening tonight. Make sure you have your proof of ownership. make sure that your name is on the title, because if you don't, you could get yourself in problem if you are renting property that doesn't really belong to you. Especially the proper owner comes in and objects, you could find yourself with a breach of contract sort of a situation. Make sure that if your name is not there, you have a power of attorney or something authorizing you to be the agent of the true or the paper owner. When you're making the agreement and you're signing, don't sign one copy, make more than one, so that you can have, and make sure it is dated and signed and you keep that. Make sure that all the things that are done are kept, on record in terms of a receipt book. Make sure you have receipt for every rent that you collect. Make sure you have receipt for every utility. Make sure you have receipt for everybody, persons who come in and probably they are the ones who do the repairs. Make sure you have your receipts. Things can happen and you may need to take the matters to court, or you may need to have other persons assist you under the ADR regimes. You will need to have evidence. Evidence is what is a game changer. So if you need to take photographs and keep them safely, all right? The same thing obtains for the lessees. Make sure you get and keep a copy of the agreement, dated and signed. Keep the receipts that you get. If you have to repair anything, because the time may come where the landlord will give you permission to repair. Sometimes it doesn't happen, that it becomes a problem right away. But if issues happen, you must be able to substantiate what you have done and give proof. And if it matter has to go to court again, and you need to give evidence, you should take the photographs if they are necessary. Just for persons who may ask the question, can the landlord increase the rent or the lessor increase the rent? Yes, they can. They can, on their own, increase it by up to 7.5%. If they feel that they need more, once they can provide the rent board with evidence of certain changes that they have made to the property, then they can get more than that. The amount can be in excess of the 7.5. I also want us to know that if a person is late with rent or they can't pay the rent on time, they should simply discuss that with the landlord or the lessor. The lessor or the landlord will not be able to take action until 30 days are passed, 30 days after the due date. That's the time when they can take you to court or try to prove an action against you. If you are in an agreement where you are the tenant and you are paying utilities and you don't pay your utilities, you can still be sued, because that is a part of the agreement, and not doing it is a breach. So once the time frame would have passed, they can take it to court for you to be urged by the court to make the payments. There's a thing called tenant harassment. Any interference with the quiet enjoyment of the property. So if you go and you change locks, or you take off door, or you take off windows, or you make sexual advances and say, this is what will have to happen because we need to patch up this or that, it can amount to harassment, and harassment is something that is not smiled at. It can cause great problem for the lessor or landlord. And I thought also it necessary to say that even in situations where you're going to part ways, the fact that you get notice doesn't mean you are to stop paying rent. Rent is payable as long as you are in possession or occupation of the property. Follow? Yes, so once you're there, you are to pay rent. When it concerns selling property, and I'm almost at the end, I just want to say to you, yes, you can. There are many persons who are very adventurous and would like to do things on their own. We are in a culture or time when it's a lot of DIY, which you call do it yourself, and so other persons are doing things on their own. But there are some things like sales that you have to be very careful with. They can be quite tricky. And my advice is that even if you're going to supervise some part of the sale process, get some initial input from an attorney. You need to make sure that the due diligence is done. And so physical checks or checks online on the ELAN system or going to the Island Records office, make sure those are done. Make sure that there is an agreement. Don't take anybody's word for it. Understand? And never pay first. Always make sure the writing comes first. It is actually supposed to be that you sign and you exchange contracts. So I should have said this earlier. There should be 2 contracts, and I sign, and I exchange with you, you sign, and we exchange, and both persons sign, and each person keeps a copy of the fully executed contract. It must be dated, and it must have all the terms. There must be nothing that is left up to the imagination. And I will just leave one last word. In terms, I said this the last time and I'll say it again, alternative dispute resolution. Dare any of you having a matter against another, go to law before the unjust and not before the saints? Do you not know that the saints shall judge the world? And if the world shall be judged by you, are you unworthy? Where there are matters that we can't work out on our own, we can get persons to help us to solve our disputes. I trust I would have dealt with the things that you'd have wanted me to deal with. And I defer now to Minister Lemar.
Thought-provoking presentation. Wonderful, wonderful. There's so much that he has expressed tonight, and I'm sure that land is not something that you want to take on your own. We definitely need the attorney to help us to go through this. I'm just going to ask you to write down your questions. Think about what you want to ask. If you're a tenant, if you rent, lease property, you might want to get some further information from our presenters tonight. But I'm going to ask you just to think about it for a moment. I'm going to take 2 minutes break. While you're doing so, as I present to you a short commercial on what we are all about. So think about your question as we come back in just a few moments.
Welcome to Sustained by Grace Ministry and Outreach, a unique ministry that seeks to heal the body of Christ through our various program offerings. These innovative programs are geared toward the nurturing of the whole man, spirit, soul, and body. Among the available programs are the Adult and Elderly Support, Relax, Entertainment, and Laugh Program, REL. This program is designed for persons heading for retirement but are unprepared, empty nesters, and those struggling with depression, mental health issues, and loneliness but need expert advice and help. Our youth ministry club is here to help young people who are losing hope because the devil is trying to stop their progress. Learn social and life skills that will prepare you to be the future leaders and winners. Sign up now for our club. We also have an exciting entrepreneurship ministry club. This is for those who need additional income, want to adequately provide for your family, get free from your 9-to-5 job, and to use your business as a ministry to serve the kingdom of God. Get involved today on your way to financial independence. Are our pastors and leaders suffering from burnout, stress, depression, loneliness, and a feeling of giving it all up and throwing in the towel? Well, we have our pastors and leaders support program called Call us today and let us put you on to an expert support team member. We also offer Christian counseling to anyone who needs it. Become a hand extended as a monthly subscriber to our education and health fund. Proverbs 19:17 says, "He that hath pity upon the poor lendeth unto the Lord, and that which he hath given will he pay him again." Donate today. Register now and don't miss these amazing opportunities. All our programs are done online and our prices are very affordable. Please see program listing and costs below and how to get in touch with us. God bless you. Sustained by Grace Ministries and Outreach, nurturing you back to wholeness and life.
Thank you very much. So you can contact us if you need further information on any of the program that we offer. So we're going into our question and answer section. So I'm going to be asking you, if you have any question, you can place it in the chat, or you can just open your mic and ask the presenter tonight. So we'll give you this time for you to go ahead with your questions.
Okay. Good night again. And to Mr. Russell, wonderful presentation as usual. All right. So on the matter of titling,
Yes, sir.
I just want some clarity. When you receive the title from the tax office, you really do not get an original, or you get an original of the original, which is it?
All right, so yeah, what I was saying is that there are two titles. There's the original certificate of title, which is the one that belongs to the government. That one never leaves the National Land Agency.
Okay.
What you get is an original, but it is duplicate, so that it is a copy of the one that exists there. But an original copy that you can use and you can show as proof of your ownership. Most persons don't usually know, but that's how it exists. Yes. So that's why you hear them call it the duplicate certificate of title.
Okay. All right. Thank you. So in the case of an adverse possession, then,
yes,
right? You that title that they issued to you. That's, let's say for the moment that that original one, as you were saying, actually could throw away that paper because it become null and void.
For the person who had the property at first. So say I had the property and I was wasting my time, and you came and look at it and had it for the limitation period.
Right.
The title that I would have had before would have been cancelled. And
also, they would come with a different
it would be a different volume and folio. But it would be linked to the one that would have been there before. Right. So they would have, say that this property was formerly on the volume this, folio that, but that was cancelled, and it gives you the date so that there is what happens is that the register makes sure that there is clarity for everybody. Once you consult the register, then you're good to go. Yes.
All right. So I'm just curious.
Yes.
Could I say I'm overseas, but somehow I'm paying taxes on the land. I've not visited it for the limited time. Could someone else be also paying taxes on the said land at the same time?
Well, yes, persons could go and attempt to pay, and then you know what? They would not stop you from paying, because you can always pay into the future. But the person who will win the game is the person who can strike up that I have been in possession. That's the most important thing. So payment of taxes is good, but it is possession that is 9 out of 10 parts of the law. So I like the thing that you said, that persons who are overseas need to have somebody on the ground. If they see a property that they like, have somebody on the ground to make sure that the land that you have an interest in, you are properly possessing it. Yes.
Or and possession mean anything that is tangible.
Put
that
some
you can
blocks
put on
on
the
the,
land.
yes, put some blocks on it, have some cows on it, have animals on it, fencing it, clearing it, those kind of acts.
And it's really foolhardy to think that I could put some blocks on there, but my competition put his goats there.
Well, it's the person who is going to have the better story, because if you put the blocks there and people know that you have had an interest, and then someone comes and is trying to, siphon it out of your hand, then it could have been it can be a battle that you can win.
Okay, you have to prove, right?
Yes,
That would sound very frightening. Well, thank you. I'll come back again.
Yes.
Okay, thank you. So in following up to that question that Marvin asked, so what if you own a piece of property and you have someone who want to rent the property, but there's no house on it, but they ask permission to put a little structure on it for the time being, and they'll pay the rent. Does that mean that that person has been possessing your property?
Well, no, because in that situation, I see a lot of that happening in terms of lease land, where persons will say you can put up like a semi-permanent structure, but you have X amount of years, and then they decide, oh, I'm not selling the property. What happens is that the land belongs to you and the property belongs to them. So in the case that you decide to part ways, then you can simply say, take up your housing material off the land, because I have use for it now. So it doesn't give you a proprietary interest, because you would have known that at some point in the future, you will have to yield up the land back to the owner. Yes.
Okay, thank you. Any other question from the audience?
Okay, yes. Thank you, Mr. Lemon. Okay,
Yes,
so Russell, is there a time for the transfer of or should I ask, how long does it take for the title to be transferred from one person to the other?
that's a very good question. It doesn't have to take a long time, because let me just tell you the process. So you have to prepare a document called an instrument of transfer, and that document has to be stamped at the stamp office. The thing about it is that they may have their checks that they want to do to ensure that things are done and in order. And after you have done that now, and you get the relevant documentation from the stamp office, it goes on to the titles office. Because of the amount of bandulo business, it's something that is carefully monitored. So there are sometimes that it may go, months, can be less, it can go through very quickly. But yeah, I'm afraid to give timelines, because there are each case might just be different based on simple things that arise. It's not a very long process, because I can tell you this, the titles office, the stamping part of it may be a little challenge, but once it reaches to the titles office, you will get it back in weeks. Yeah. Yes, sir.
Okay, so I'm seeing a hand raised by Samsung Galaxy. Can go ahead.
Person left.
Okay. All right. So one of the problems that we have in Jamaica, Pastor Russell, is sometimes when you rent persons, she said she can't unmute. Sometimes when you rent persons your property, right? So they don't want to come out, so they go and apply for extension. Yes. And they give you a hard time to come out. So every time that you're ready for them, they go and ask for more extension, and they're not paying rent, whatever the problem is. How can that be
You're not going
resolved?
to get extension forever. And the thing about it is that renting property is a serious thing. And that's one of the things I try to explain tonight. Renting
Okay.
property is giving persons exclusive possession at a terms, for a term certain at a rent. And boy, I don't even want to say what is in my mind to tell you about that. It is so much more serious than how many persons take it, because it's as if you have something tangible and you are yielding it up to the person that you're renting it to. And because of that, it's not somebody you can just kick out like under the license. You say, oh, I don't want you here anymore. This person actually has an interest. So you have to treat them with respect. You have to make sure that whenever the reasons for which you are trying to use to get them out, you have to make sure that that reason is viable. So some of the reasons that the reason why a lot of landlords get themselves in a precarious position is because the reason that they put forward is just not cutting it. It is not cutting it at all. So really and truly, that's why when they go to the courts, because really and truly, what's supposed to happen is that if the person's not paying rent, you give them a notice to quit. When that
Okay.
notice expires, you can give them another one. And once they have not paid attention, give me 1 second, please. 1 second.
No problem.
Welcome to Sustained by Grace Ministry and Outreach, a unique ministry that seeks to heal the body of Christ through our various program offerings. These innovative programs are geared toward the nurturing of the whole man, spirit, soul, and body. Among the available programs are the Adult and Elderly Support, Relax, Entertainment, and Laugh program, REL. This program is designed for persons heading for retirement but are unprepared, empty nesters, and those struggling with depression, mental health issues, and loneliness but need expert advice and help. Our youth ministry club is here to help young people who are losing hope because the devil is trying to stop their progress. Learn social and life skills that will prepare you to be the future leaders and winners. Sign up now for our club. We also have an exciting entrepreneurship ministry club. This is for those who need additional income, want to adequately provide for your family, get free from your 9-to-5 job, and to use your business as a ministry to serve the kingdom of God. Get involved today on your way to financial independence. Are our pastors and leaders suffering from burnout, stress, depression, loneliness, and a feeling of giving it all up and throwing in the towel? Well, we have our pastors and leaders support program. Call us today and let us put you on to an expert support team member. We also offer Christian counseling to anyone who needs it. Become a hand extended as a monthly subscriber to our education and health fund. Proverbs 19:17 says, "He that hath pity upon the poor lendeth unto the Lord, and that which he hath given will he pay him again." Donate today. Register now and don't miss these amazing opportunities. All our programs are done online and our prices are very affordable. Please see program listing and costs below and how to get in touch with us. God bless you. Sustained by Grace Ministries and Outreach, nurturing you back to wholeness and life.
Pastor Russell? All right, so I noticed there are some questions in the chat.
Thank you very much. Thank you very much for that. Yes. So, oops.
All right. All right, do you want me to go ahead with the next question?
Yes, ma'am. No problem.
All right, so how long does a person have to pay taxes for before they have a legal claim to the property?
Okay. Well, in terms of the registered land, it would be for, up to 12 years. For the unregistered, it would be 30. And for crown land, it would be 60. As I said, the more time that you have there, it will be better for you, because once you are able to prove that you have been there for a certain amount of years, and I did say too that from up to 10 years, once you are there for 10 years on a registered title, really and truly, the person who is the owner has not come back, has not paid it, the scant regard, then boy, they're kind of dark when they decide to come back. So once you are there for those amount of years, then you are in a good place to have displaced or dispossessed the paper owner. Yes.
All right, and a follow-up question. Also, if a child is not given a property on the will, in case of death, would that child have a legal claim to said property?
All right. Well, if there is a will and the property, it depends. So in the case where X has a child and he only has a child, and he has a property, he dies, he doesn't leave a will, then that child can, do the administration, go through the administration process, and after that now can have their name put on the title for the property. If it's a situation where there's a will and the property was not mentioned, that property would fall to intercessor, so that person could again go under administration and they would get the property. So I think the answer to that question would be yes. So if the child, if a child is not given a property on the will in case of death, that child can still have a claim to the property. Yes. It's a different situation if the property is given to somebody else in the will. Now, if it's given to somebody else and you want to contest that daddy or mommy did love me too, and my name not there, you'd have to go and take that up now before the courts and ask the court to look at whether the will is actually valid, whether the person was of the legal capacity and the mental capacity to make a will, or whether there was any forcing or any kind of curried favor where other persons are concerned. So that's the only situation that I see based on your question.
And if the child is underage, how you will treat with that?
If the child is underage and the parent would have died and left a property, if there are other children, they will have to report the matter to the administrator general, who will supervise the interest of the child to make sure that they don't run away with everything. And the administrator general will hold back a certain portion of whatever is to be there for the child and make sure that the child gets it when they reach 18. Yes. So the administrator general, once you have a property or you have a child being a part of a dead left situation, as we call it in Jamaica, you make sure you go to the administrator general's department and make a report, because they will look. It might not be something that many people relish, but it's a legal way to do things, because at the end of the day, the interests of the child must be protected. They are vulnerable. Yes, ma'am.
Okay. Any other question from our audience?
So, okay, just one last one from me
No
here in
problem.
regards to rent of
Yes, sir.
property.
Yes, sir.
Does the rent board set a margin or cap as to what a person is allowed to rent, or they're free to do it of their own?
Well, I don't know if there's, they can give you advice on what is reasonable rent if you contact them, because persons are free to, there's a thing that they call freedom of contract. I can have a place that is worth $1 and I rent it for $1 million to the right person. The rent board will only come in wherever that person will say, boy, you know, really and truly, am I getting value for my money? So when you contact them now, they come into the mix of things. But ordinarily, they will not come and bombard you. But if they are contacted, you can get good advice from them as to what is reasonable. So I'm glad you brought that in, Rev, because a lot of persons don't know that the rent board is there to protect or give advice and protection to both the lessors or landlords and the lessees or the tenants. So yes, we can always go to them to ask questions and to get the good advice that we need.
All right, thank you. Any other questions before we close off? Okay, so once again, I want to say thank you, Pastor Russell, Lawyer Russell, for a wonderful session, a very informative session, and I'm sure it will be beneficial to our audience. Again, I'm going to ask you.
I just want to just say thanks to you and to Rev for having me, and I am very happy for the opportunity. And I just want to say that I'm hoping and praying that the Lord will bless this ministry abundantly, because when I listened to your advertisement a while ago and see the array of things, I will be contacting you to see how I can, you know, be a part of what you are doing. God bless you
very much.
A lot.
Thank you. And his contact information is on screen, and I'm going to give you a second to screenshot it or to write it down, because you might be needing his service in the future with how things are going in Jamaica with land, and we are in an age where it's construction age. Land and building is going up every day, everywhere, and the price of housing are appreciating. And you might just want to catch a hold of your piece before it gets too expensive or none is left for you to have. So please take his information and you can contact him in case you need him. Thank you again, everyone, for joining us, for participating, for making this show relevant. And we thank you for coming on next week as we look at another interesting topic. Have yourself a blessed weekend, a blessed night, and we're hoping that we will see you next time, same time, same place. Be blessed. Thank you very much.